Okay, folks, so we can finish on time and get you to your drinks. We're going to get going. This is the last panel of the day. And we are going to pick up right where we left off with Polly. It's going to jump right back into unlawful means conspiracy and help us understand this powerful tool and help us understand how it's different from lawful means conspiracy.
Thank you. Yes. I spent the whole of the break researching and studying and boning up for this. I'm not even sure which part of my slides covers this, so you might have to just keep flicking through until you get to the one that looks like this, that says BTA and Krapanov.
Okay, well, it's not working at all right now. Anybody? Can you help me with this? Okay.
I can just hold my slide up.
Oh. Not too far.
There you go.
Got it.
So as I mentioned before the break, BTA and Krapanov is a recent case. Judgment came down in July of this year. And it's pretty much as simple as I explained before the break. We already have this existing tort of unlawful means conspiracy. And in order to found a tort in unlawful means conspiracy, there has to be an unlawful act, and it can be either a criminal or a civil wrong. And as a result of the unlawful act, there is some harm that is caused to the claimant, some damage, some loss that flows from that. And what the judge said in the Krapanov case was the evasion of a freezing order is a sufficient unlawful act. Now, that might not sound like too much of an advancement on the original. I just realized how much more empty the room is than before the break. Was it something I said, Ed?
But they're all awake, so that's a good...
They're all awake. All right, I'll try not to take it personally. In any case, it doesn't seem like too much of an advancement on the pre-existing tort of unlawful means conspiracy, but it does help to have it determined by the court that the evasion of a freezing order is sufficient to form the basis of the unlawful act. So applause all round for getting a new tort. We always like it on the claimant side when we get one.
So it's essentially, in American terms, aiding and abetting the violation of an injunction, if we were to put it in American terms, right?
Yeah, well, I mean, those are English terms as well, because aiding and abetting is a criminal concept here, and in order for there to be a conspiracy under criminal law in the English courts, aiding and abetting, aid, abet, counsel, or procure would be the terminology that we would use. This has to be just some form of combination, and very helpfully for anyone who is going to seek to make use of this new tort, the combination does not have to be constant. What I mean by that is you don't have to have joined the conspiracy on day one. You could have joined the conspiracy on the last day as long as you had notice of the freezing order and as long as you assisted the underlying defendant to evade the effect of it, then a claim can be brought against you and liability can be found. It's probably worth saying a little bit about the factual circumstances behind this case and who was Mr. Krapanov, the unfortunately named Mr.
Great name,
Krapanov.
though, for a fraud case. I just love it.
Yeah, I might be pronouncing it wrong. I don't know. Mr. Krapanov is Mukhtar Ablyazov's son-in-law, and he is married to, can't remember her first name, but Ablyazova, the daughter of Mukhtar Ablyazov. There was a worldwide freezing order in place against Mukhtar Ablyazov from 2009, and despite the best efforts of Hogan Lovells and an assortment of international asset tracing specialists, no assets could be found. So $10 billion had been spirited out of Kazakhstan, mixed around in London through some offshore service providers that are based here, and disappeared into the great wide world. The break in the case came in, I believe, about 2014, when a private investigator approached Hogan Lovells and said, I have some information that might be of interest to you about Mr. Ablyazov's assets. He said, I've hacked the computer of a fiduciary in Dubai. Here's all of his emails. Perhaps you'd like to take this to the English courts and rely on it in evidence, because these emails show that this fiduciary in Dubai was managing assets that were really in the beneficial ownership of Mukhtar Ablyazov. And Hogan Lovel, according to its court filings, said, "No, I will not buy that tainted material. I will instead go to court and get a Norwich Pharmacol order forcing you to disclose it to me lawfully." They may have even said, "I will not even look at that material because it is so tainted, because you hacked a computer and stole it." I don't really know what happened behind the scenes. Just role-playing it out in my head. In any case, the courts were happy to grant a Norwich Pharmacol order to Hogan Lovel, who then received from the fiduciary all of the information related to Mr. Krapanov and his management of $500 million worth of assets, which included a large publicly listed company listed on the London Stock Exchange. And the $500 million had flown in through Dubai, through a bunch of offshore companies incorporated in Dubai and in Mauritius and the Seychelles, and were used to purchase, of all things, shopping malls in New Jersey. I don't know why. Who knows what goes on in the minds of Kazakh fraudsters. But there you go. That's where the funds ended up. And Mr. Krapanov fought a long-running rearguard action. First, he said he couldn't come to the UK because he would incriminate himself if he did come here to give evidence. Then he said he couldn't come to the UK because he would be extradited to Russia, which he would have been. And then he said he would give evidence by video link, and then the video link wasn't working, or else he wasn't available on that day. And so judgment was entered against him.
Well, I think one takeaway is that I like any new conspiracy-based remedy because it's a fault spreader. You have the underlying fault, and then you have something. And the beauty of it is that if you can tag one of the conspirators with jurisdiction, you got jurisdiction over the entire conspiracy. And so, at least in the States, so if you can tag one and pin their feet to the floor, and even if there's 10 more and they're scattered all over the world, you got them. They don't have a personal jurisdiction argument to the point with regard to the conspiracy. So it's a nice way to reach beyond the border and grab assets and or grab culpability and without having to necessarily go around and serve out of the jurisdiction and do all the other crazy things that add like $1 million to the cost of the case. So it is a beautiful, powerful tool, and lovely to hear that we now have this. Warren, you wanted to say something about this.
I was going to say it's not every day that a new tort is born. I mean, this when we were practicing, this was an interesting one. It should be possible to replicate on the U.S. side. And just here's the scenario I'll give you. Just think about what it would be like to use this theory against someone with actual D&O insurance. So you've got a director who participated in the intentional evasion of a court order. That sounds like something that we'd be very interested in, and keep going.
Yeah, keep inventing new torts for us. That's
I know, because we recognize English case law, so it's actually very interesting.
I just want to make one programming note. We did not vote Margot off the island up here. She has an emergency phone call in one of her cases, and she's having to deal with it, so she may or may not come back in, but for now she has to deal with that. So,
can I make a point about the presence of Margot and I on the panel?
If you'd like, yes.
I ran the math earlier. Margot and I are officially 40% of all women speakers at this conference, the two of us.
Well, congratulations to this panel, then.
To this panel for our diversity. Yes, you are. There are 5 women speakers. I counted them. So 40% of them are on this panel. So let's hear it for your panel.
And the top 2.
That's right.
And the best panel. Yeah, of course. On top of that. So we are going to move on to our next topic. Thank you, Polly, very much for that. Where are we at?
Yeah, I think the next topic is how this is being applied in Jersey. I mean, this is really an interesting issue because what we have is the birth of a tort. And
yes, in fact, what I'm going to talk about is a very recent English case rather than a Jersey case, but there's no reason to think, because the economic torts apply in Jersey, that you wouldn't have some application there. One of the key questions that we often come across in asset recovery cases is what claims are available against individuals who've been involved in the management of a company that's gone into insolvent liquidation. And the issue that commonly arises involves what's known as the corporate veil, and those who are prepared to take advantage of the corporate veil and to say, well, you contracted with the company, it's nothing to do with me. As we know, a company is a separate legal entity, separate to the individuals who set it up. And I think it's fair to say that the courts in England and Wales have been reluctant to pierce the corporate veil, save in limited circumstances, classically where a person fraudulently imposes a company to evade an existing liability and there's no other remedy available. And of course, in the offshore context, it's common for individuals to structure their businesses and activities through companies, often run by corporate service providers, directors who may have little involvement with the day-to-day activities of the underlying asset. And this very recent case, this is an October 2018 case from the English High Court. It follows on from what Polly's been talking about in the tort of unlawful means conspiracy. It provides an alternative to piercing the corporate veil on the right set of facts. It was a construction case, so on the face of it, little to do with offshore, but it seems to me that it can be very useful. It arose out of the renovation of a 14-bedroom, 200-acre estate in Devon. And effectively, this house, it belonged to a gentleman called Michael Lloyd. He'd structured the ownership of his house through a number of companies. It was owned by a Cypriot company, and there was a long lease granted to another company. And that leasehold company, it contracted with a firm of building contractors for the renovation of the property. It was a £5 million renovation contract, but in truth, this company, the leasehold company, was just a facade for Michael Lloyd. It was him who was going to be living in the house. It was his English home. And that company had his brother, Christopher Lloyd, as the director. And the court, the judge, when he gave his judgment, found that effectively Michael Lloyd had, in his words, called the shots. Now, the renovation was funded by Michael making loans to the leasehold company. And partway through the renovation, when £1 million was owing, Michael stopped funding, and the original contractor was left unpaid. What Michael and his brother did was chose to put the company into liquidation, and it was undercapitalised. The judge says this shows the perils of contracting with an undercapitalised company. When it was liquidated, there was $150,000 available to it, very little indeed. And it was clear that the decision to put that company into liquidation was a cynical one. Michael knew the contractor was vulnerable because the company didn't have the money and it didn't have any personal guarantees, as you may think it might have been wise to get from the Lloyd brothers. But they clearly, the brothers, anticipated being able to rely on the separate corporate personality to hide behind the corporate veil. Well, the contractor didn't sue them it didn't sue the company. No point in suing the company. What it did was sue the Lloyd brothers under a number of economic torts, what Polly's been talking about. It sued the Lloyd brothers for inducing the breach of contract because the company was due under the contract to pay instalments of this $5 million to the contractors. It didn't do that. And it sued them both for unlawful means conspiracy. Now, it may be said that there's been a reluctance to make use of economic torts in asset recovery, not least because there have been relatively few cases which set out the criteria and the requirements for establishing them. But the fact we have this case, it's a long case, it's 90 pages long, the judgment, and I no doubt won't do justice to it. But the two successful claims were inducing breach of contract. The contract had been breached, and it was Michael's withdrawal of funding from the company that had caused the contract to be breached. Just preventing the performance of a contract, not depriving it of money, that's not enough to induce the contract. Prevention's not enough. You've got to induce it. And what the judge found, was that the two brothers had decided in January, 4 months before the breach, they had decided they were going to liquidate the company, and they had decided they were going to do that by depriving it of funds, and the funds that were available to the company were in due course diverted to another company which completed the renovation, and Michael got the benefit of his house. And of course, they said, well, we've just prevented the contract, we haven't induced the breach of it, and by the way, we hide behind the corporate veil. The court found no, this was a cynical decision. You have induced the breach of contract because you should and could have made the money available, and you didn't. And by putting it into liquidation, that establishes the tort of inducement to breach the contract. They were also guilty of unlawful means conspiracy. Again, the court found they were complicit in the decision to liquidate the company and avoid the debt. And I think the lesson that we can take away from this practical application is that in the right case, these economic torts, when you've got people who are playing fast and loose with companies, knowing full well that if they're liquidated, they're not going to be good for their debts, this is another way of getting at the people who stand behind them. I think in the offshore context, where you have special purpose vehicles that are undercapitalized, it could be very useful at getting at people who are controlling them from afar. And also, of course, nominal directors, professional directors may be at risk themselves for conspiring with those third parties who are standing behind the company if things go wrong. So I think it goes on from what Polly said. It's not an offshore case, but I think it's very useful in asset tracing and offshore to give us another string to our bow when people are arguing that the corporate veil applies.
If it works there, a great presentation. If it works there, think about how well that might work with facts of fraud. One question I have is, did the court make any finding, or did the court require that there was intent at the time they set up the corporate structure to use this later for a fraud?
Well, that was originally pleaded in the case, and that the judgment isn't entirely clear. That allegation was struck out at an earlier stage, so
that's even better, because you didn't have to. Some of our law in the United States about piercing the corporate veil requires either that you have to demonstrate that the corporation was formed for an illegal purpose or used for an illegal purpose, and that varies from state to state, and the law is all over the place, and some of it's quite bad, just undeveloped. So that's fantastic. Anything to add to that?
Arrows and quivers, I think, goes to the next topic. The next set of topics have to do with what many on this side of the table, and I think a lot in the room, define as success, and that is asset seizures. It's how we get paid at the end of the day. It's how we actually recover for our clients, most of whom for our creditors or victims. And we have a few topics on this. I'll tell you, mine is not the best of news. This summer we talked about an interesting development in the New York law that provoked a lot of audience discourse, and that was what New York is calling the global seizure, the global attachment. It's now black letter. Nobody's really disputing it. New York courts are purporting to exercise jurisdiction over property worldwide. That's a very good thing. What I'm going to report about is a decision on the West Coast where the court wouldn't even take jurisdiction over property in its own state. It has a lot of implications. I think it probably came out the wrong way. It's on appeal. I think the court may duck the issue and remain on jurisdictional grounds, but here's the premise. Let's say that you are retained or you are investigating a fraud, and this is the whole thing we do, right? We link assets to a fraud and then via judicial means try to apply those assets to the fraud or exert legal pressure so that a settlement is reached. Let's say you had a crystal clear case linking the Empire State Building to a fraud of the type that we've been discussing in this room, judgment enforcement, judgment evasion. That Empire State Building is owned by an offshore company. You've linked the offshore company to this fraud. Can you seize it? An answer from one district court can you seize it in the absence of other jurisdictional predicates? Let's just say this is a largely offshore fraud. One district court has suggested the answer is no. There are due process principles in the U.S. One of them limits the ability to seize assets to cases where there is a clear connection between the property and the cause of action. How connected does that have to be in order to constitutionally exercise jurisdiction? I will submit that in this case it was pretty clear. And the district court found the connection to be insufficient. The upshot and implication of this is pretty severe. This has never really been litigated, or at least not in 45 years, and the Supreme Court hasn't taken this up in a while. What I will submit the answer is yes. The second you make the statement, this asset is connected to this fraud, you've met your burden. But it's a hotly litigated issue, and it's one that actually affects the bottom line. So I will submit that we are watching and waiting. It's something that I think the Ninth Circuit immediately noted as having precedential value, and I think that they're going to avoid the issue and remand the case, vacate the judgment, and let it stand. But keep it in the back of your minds, because even when you think you may have hit a payday, the question is always going to come down to, can you execute? And in this respect, I think we have a step backwards.
Well, every single U.S. law student studies a case called Schaefer v. Heitner.
That's right.
And that case deals with the distinction between in personam jurisdiction, in rem jurisdiction, and quasi or quasi-in rem jurisdiction. And every American law student hates studying that case because it is just so confusing. And it's very difficult to get your arms around. And a lot of courts struggle with this. Why would a quasi-in rem claim, which means you don't have to have personal jurisdiction, but the remedy is limited to the value of the thing, or a true in rem claim, a tracing proprietary claim, not get around this problem?
That's right. Well, this is what it all comes down to, this quasi-in rem, in personam thing. And what we talked about this summer was that the New York courts have merged the whole concepts. In New York, it's if you have personal jurisdiction, you have jurisdiction over property worldwide. And this caused a stir. Can you imagine if you have jurisdiction over someone and that someone has title to shares in a Jersey company? What a New York court will say is that we've got jurisdiction, we can order you to turn over those shares. What this court is interestingly saying is if you don't have that basic form of personal jurisdiction, either general or specific, even if the asset is located in the U.S., you can't go after it, absent some form of additional connection. And the second you get to proprietary, where it's literally the asset transferred out, then you're in rem and you're all good. This is an in-between type of case, but it's the type of thing that those in this room that we deal with. Because often there's a step or two in between the fraud, the judgment evasion, it's commingled with other assets, and then it gets sped out into the form of this other new investment. And without being able to breach that gap, it can be very difficult and challenging.
And this is where I think cases fall down because it's not the sexy part of what we do. It really requires a lot of grinding and analysis and figuring out what happens ultimately with how you plead it. And maybe grinding was funny. I'm not sure. I'm not sure the context that made Polly laugh, but maybe I can think of it. At the end of the day, there was a hugely bad case in Florida, which some of you are aware of, which I reported on a couple of years ago, involving a court saying we don't have jurisdiction, in personam jurisdiction, will not allow us to force someone to bring shares offshore into our jurisdiction. It was a horribly decided case, widely panned, and it did not follow the New York jurisdiction.
That's right.
And then subsequently now there's been cases in Florida that have gone the other way.
Okay.
So your case
we helped out on that one,
So-
but this is a cautionary tale.
Yeah.
This, and I think it's going to come out the right way, but it's something to be mindful of.
How you plead is critical, absolutely
If
critical.
you're seeking assets in California. Is
Not
that
just
have I understood that
California,
right?
it's
No.
the whole U.S. in
The
principle.
whole U.S. in principle.
And
Okay.
in principle, this is constitutional.
Yeah,
So
it
it's
is,
an interesting one.
but it's a district court ruling which doesn't necessarily have, precedential value per se, but other
be
district
cited.
courts will look at it and say, was this ruling was it well-reasoned, and can I rely on it? And some of these cases
Yeah.
are outcome determinative because they're really bad facts, and the court's like, I'm going to get this person, or I'm going to let this thing go, and so we have to let this develop, but it is something that we're just waving the flag and saying, really, you have to really think this thing through before you plead these types of cases
Yeah.
in the States.
And it's 50 years since anyone's really looked at this. So it's something that's coming through the pipe. As I said, I think it's going to get turned around, but it is germane for all of us here. Which,
Just a question. How do they reconcile that with civil forfeiture? Because civil forfeiture
that's a good question. I cut my teeth doing that. The Rule B, civil forfeitures, which is what they're all based upon, it has been determined in an advisory note that Schaefer v. Heitner does not apply to Rule B actions. Just period. It doesn't apply in admiralty either, in shipping cases. That analysis could be expanded, But yes, if I was defending a civil forfeiture case now, this would be my first line of defense. Yeah. And if you have a civil forfeiture case for, let's just say, someone who has not acted in the U.S. but has an asset there, you're going to need to show a nexus. But in the civil forfeiture cases, I'm going to guess if you've got criminal jurisdiction, then you're going to have personal jurisdiction in the first instance, which is going to solve all your problems.
Yeah, sometimes it doesn't work that way. You've got criminal jurisdiction in Southern District of Florida and that.
Can we use the microphone, because we're trying to record this and we want to hear what you have to say is important.
As you know, sometimes that's not the case. You've got criminal jurisdiction maybe in the Southern District of Florida and the assets in Iowa. So that's why.
This could be an issue.
Yeah, well, civil forfeiture probably is technically unconstitutional, but that's a whole different discussion.
You're talking to the former forfeiture guy.
Yeah, I hear that, but if you really want to be doctrinal about it, it's probably unconstitutional. But I'm happy it exists, and I'm happy it works.
No, and this is a good back and forth discussion. But the reason there are those who say it's unconstitutional, it's partly this. There's the notice and the ability to get your property back requirement, but this notion of quasi in rem jurisdictions, what everything sort of turns on.
You get to argue against a lot of empty chairs in those cases, and when you really get sticky is when you have victims or others that are saying have a competing interest in that asset vis-a-vis the U.S. government. That's where that issue gets sorted, I think, and may get sorted ultimately, but hopefully not. But I know we're going to...
Well, yeah, I mean, I was just going to say this is seizure, but what does it take to get a seizure in Jersey?
So in 1962, Hout Bay Lobster Fishing Company was established in South Africa, and its business was to catch and harvest and sell on West Coast lobster and South Coast lobster that populated the South African seas. The problem started when the company deliberately and on a massive commercial scale started to exceed its lawful quotas and caught unlawfully a very large number of lobster, which they then shipped off to the United States of America, where those lobster were packaged and sold on to U.S. customers. Massive profits were made, and the allegations were that the profits were moved around the world through various offshore jurisdictions and were indeed put into offshore trusts. And during criminal proceedings that followed, it emerged that some $23 million of trust assets were sitting in portfolios held in Jersey banks. The company was prosecuted in South Africa in 2002. It was fined, its boats were forfeited, and effectively the company was shut down. The company had been owned by a family and run by the father in particular. And the father and his sons were all, by this stage, U.S. resident, declined to go back to South Africa, but were then subject to a separate prosecution in the United States of America, because the United States has pretty tough wildlife protection legislation in what's called the Lacey Act, which made it an offence to transport or sell any wildlife that had been caught in violation of foreign law. So the father was sentenced for approximately 4 years' imprisonment on a guilty plea. And after some 13 years of argument in the sentencing that followed, believe it or not, which could be the topic of a separate talk, he ultimately faced a confiscation order of $37 million, of which the US authorities obviously sought to target the $23 million that they knew about in Jersey. And therefore they wrote to the Attorney General of Jersey seeking assistance in terms of restraining those assets. There were some problems with that application. Firstly, the assets were held in a trust, and the father in particular was, on the face of the trust documents themselves at least, said not to be a beneficiary of the trust. So query, how could trust assets possibly be used to satisfy a confiscation order that was directed personally at the father? Secondly, despite the lengthy passage of time, the US authorities had not done very much at all in the context of tracing, to the extent that when the matter came before the courts in Jersey, the US prosecutor swore in her affidavit that she hoped that one day she would be in a position to be able to trace the trust assets back to illegal activity, but that she was not in a position to do that at the time of swearing her affidavit. And thirdly, a further problem was that although there had undoubtedly been a wide range of unlawful activity going through the United States, there was also lawful activity in the sense that the South African company had lawful quotas, and therefore some, at least, of the lobsters going through the USA had been caught lawfully and therefore sold lawfully. So how does one distinguish what lobster was sold lawfully and what lobster was not? But the upshot of it all was that in terms of an interim restraint order, the Royal Court of Jersey was not untroubled, but felt it could maintain a restraint order at an interim stage pending the final disposal of the case. The problems that I've outlined were considered issues to be determined at a final hearing, but were not fatal to the Attorney General's application for a restraint order in support of the US authorities. In particular, there was some evidence that at least the initial funds that had gone into the trust had come from the US business. And although it may be that those funds had been dissipated, the Royal Court still felt that there was sufficient at an interim stage to maintain the freezing order. It's right to say that the trustees who I represented, who challenged that position unsuccessfully in the Royal Court, then brought an appeal to the Court of Appeal in Jersey. But that appeal is not going to be heard because effectively settlement has been reached whereby something in the order of $6.5 million will be paid over to the US authorities, but the majority of the assets in Jersey are or have been released. But the wider principle really is that the Royal Court was very anxious to provide the greatest possible assistance to the US authorities, and therefore at the interim stage at least was prepared to maintain the status quo pending the outcome of any final determination when the court could take a more informed view of all the evidence in the case.
Andrew?
Yeah. Well, what I'd like to do here is, prior to our break, I conveyed that it's really the past decade or so that the Canadian courts have been trying to push debtors into the light and give creditors, plaintiffs, more power. This applies with equal force on asset recovery in the context of freezing assets, both with domestic and foreign proceedings. And I'd like to go through a short trilogy. Starting off in 2015, our Supreme Court enforced the proposition that for a foreign judgment to be enforced, it requires less than a real and substantial connection to the forum, meaning that, and this applies or is shown here, is Chevron, which you've heard, is there you have an Ecuadorian judgment, arguably obtained by fraud or some concerns with that, and ultimately our court still found that Ontario had jurisdiction to enforce this. Ultimately, it didn't for separate reasons relating to piercing the corporate veil. It sounds like Jersey and England, Canada takes a very strict approach to piercing the corporate veil. But putting that aside, it's an example that our courts are willing, and maybe in comedy, to recognize foreign judgments. Taking that one step further...
Can I just mention on that point? Untethered. So the issue is, just to draw a comparison, the issue is when you are seeking to enforce against an asset or a company that is not the judgment debtor, and you're seeking to enforce your judgment, is it untethered to the actual jurisdiction over the judgment debtor? Because many times the asset is now in another form that's not in the name, and most times not in the name of the judgment debtor. So this issue has been plaguing our practice for years and years. It sounds like Canada's made a major step forward with regard to not requiring that tethering.
Absolutely, and that plays into the next case, and all these cases are within the past few years. Next one was a judgment obtained in Paris. The creditor came to Canada to freeze assets, and the party was not in Canada, but simply owned shares of a publicly listed Canadian mining company. And it was able to freeze the assets that were at the brokerage, and when it came time to pay dividends, the company, mining company, Canadian mining company, was forced to send the dividends in trust to be held for this foreign judgment. And it upheld on appeal, and then ultimately, for separate reasons, it fell apart. It determined that the debtor did not own the shares, again, through trying to get through this corporate veil, which failed, again, just like Chevron. But again, the defendant is not in Canada, and it's just his assets. And we have another example, 2017, where we have a judgment in Hong Kong, and a freezing order was in the process in Hong Kong. The creditors came to Canada to obtain a worldwide Moreva injunction. There, the defendant argued, saying there is no persona jurisdiction. In other words, the individual here was in Hong Kong. It was unknown if he had any assets here. But the court took jurisdiction on the premise that he was the chairman of a Canadian-listed company. This case is of importance to me. Less than a month now, I'm going to be arguing an issue about getting jurisdiction over individual independent director of a Canadian company who's in Singapore. And I'm taking the view that this particular case that I'm referring to, which some of you may have heard of, involves a company called Sino Forest. My case, I'm saying, is just one step beyond that. Here I have an independent director, and incidentally, he's one of the only few individuals that are collectible here for my clients. But I'm again noticing this trend within at least the past decade, more enforced within the past few years, that the Canadian courts, at least in Ontario and British Columbia, seem to be in the view to protect creditors and really willing to hear the equitable reasons why to help the creditor. So in the event that you find yourselves that there's a connection to Canada, like I say, I like to say myself, is put your story into a Tiffany box and give it to the judge and try to get him on your side. And we'll find worldwide jurisdiction.
I think that's not an accident. If you've been coming to this conference for the last 10 years and other conferences, I know, David, don't hate me for saying that, but there are other places that people meet and talk about these issues as well, and you see this exchange and the other exchanges that you see throughout the day, it is a direct result of that constant pressure for change that is being brought by us exchanging information and trying new things in other jurisdictions that we learn here and are pushing that, coupled with the fact that, and you talk about the discovery piece, we talked about it before before the coffee break, many times we're getting the case as the victim's counsel or without any documents because the fraudster has all the evidence. We have very little. Getting judges to the mindset, certainly in the common law jurisdictions, it's still a battle in the civil law system to allow us to get the evidence almost on the come, based on good allegations, but without that underlying evidence, is happening. It's changing, and I think it's happening because of this kind of exchange. It is not an accident.
Just on that point, we've been at this conference for, I think, almost 8 hours now today, and no one has said the initials GDPR, which I think is actually technically unlawful in this jurisdiction to hold a conference without talking about GDPR. So
why don't you? I know there's been a development. Why don't you?
Just to make sure that we do actually keep ourselves on the straight and narrow.
Yeah, let's
on
not
this
get
point.
arrested.
Yes, because well, you were talking about discovery. You're talking about disclosure in the context of us as victims' counsel, and we're all very moralistic and self-important with that, saying how we're on the side of right. There is a growing body of defensive action in this jurisdiction based on the principle of data protection and data privacy. So you have these two competing interests that are alive and are areas of new law. One is about transparency. We have a world of journalists and investigators who have themselves decided that it's their mission in life to expose the private workings of people the world over.
Hear, hear.
Then you have a competing activism that is all about privacy. I have the right for Google not to know what I looked at on Facebook, whatever. And we as asset tracing specialists find ourselves in the middle of those two competing interests. And GDPR comes along at exactly the right time when someone who is seeking to conceal their beneficial ownership of certain assets, they have a new platform on which to make that argument, which is you have breached my data privacy rights by trying to find out where I hid what I stole. And if you think that that argument is unattractive, it is being made. I have had it in present cases already. It looks like when I said GDPR, the room came to life, and now people have questions. So are we allowed to answer some?
We can. We have one more topic to go, so let's just keep that in mind. But let's do, because this is and just to make a general statement, it's like it's a pendulum, right? The pendulum swings one way, and then it swings back, and it keeps moving back and forth. But question.
Thank you very much. Going back to GDPR, Article 86 allows the public interest to disclose information using Article 10, freedom of expression. So GDPR, you can use that to a certain extent, but journalists do have that right of access through that way, especially through Article 86.
It is. I will tell you, on our side of the pond, GDPR is mystifying. We're scratching our heads and talking to all of y'all to try to get answers to some of this stuff. And it definitely is impacting our discovery in the United States. It's coming up. So it is making its way to some degree across the pond.
We have mostly lawyers on the panel, but I know there's lots of investigators and corporate investigators in the room who will have felt the impact of the long arm of GDPR already. The scenario, or the death scenario that we have faced already, in fact, on May 24th, I got served with my first GDPR breach notice, which was the day it came into force. So we had to bone up fairly quickly. And this was the scenario that an internal investigation report done by a client who was owed 35 million euro by a debtor had an external investigator conduct some investigative work. And there was one line in that investigation report which made reference to something unrelated to the debt, and it related to a family issue. The debtor bribed an employee of the client company to obtain a copy of the investigation report and then threatened a breach action under GDPR for misuse of his personal data because there was one line in that report. Now, in olden times or in America, you would laugh that away. But here, in the modern world of GDPR, you have to take quite seriously an action for breach, not necessarily because there are huge damages that are going to flow from it, £10,000 maximum, but the reputational damage and the impact of then suddenly being the first GDPR breach action is what I think led our client to treat that quite seriously indeed.
It is a serious issue.
And this goes to that implied undertaking. I mean, the question Ed posed earlier was a good one, and this is an answer which is absolutely not under GDPR.
Yes, And in fact, we have an action for collateral use that is currently being challenged. So we want to use material in a private prosecution that we obtained in a civil Norwich Pharmacol order, and the defendants are saying, I'm going to oppose your request to the judge for collateral use of that material.
On GDPR?
No, actually, just on I don't want to be the subject of a criminal prosecution. But yes, there are GDPR arguments in the mix.
If you push back into the sort of the murky depths of where these things come from, they usually come from one of two sources. One is just a legitimate concern, usually born out of some privacy rights, I will say, run amok. Others may disagree. And it just takes on a life of its own, and there are unintended consequences. And there's not much you can do about it except go to courts. That's why we have courts, to trim those things back and deal with them, and legislatures can deal with those things as they come along. Also, though, there are some of these doctrines and developments that come from those who wish to make things harder for us to do. And there are people and groups out there that are thinking about this, and they're very smart, and they're subtle, and they're powerful, and are trying to make what we do harder. So we have to always be aware, try to look for the motives. I guess cui bono would be the phrase of the day. Who benefits? Looking to see who benefits from these types of things. It is interesting. It's worth. That's where the reporters, the Fourth Estate, who are not the enemy of the people, who really we rely on you. We rely on the reporters and the journalists to get this right and to get the word out and to report on this, because only you guys have the appropriate megaphone to get the word out to the rest of the world, and to investigate the background of what's the real motives behind some of these things. So the work you do for maybe inadvertently for us as you report on stories is invaluable. And David recognizes that. That's why more reporters, more journalists come to this conference than any other conference I go to in the world. It is definitely a huge benefit to this practice. The last topic we have, and we're unless you want to add anything.
No, it's yours.
It's my topic, and I'm going to try to speed through it because I don't want to keep you from drinks. And I want to just point out some good lawyering and some developments that may benefit you in other cases. For those of you that do judgment or arbitral award collection against sovereigns, you know that is a very, very, very rocky and hard field to plow. It is very tough. And so when we see developments in this area, we like to report on them because it is intentionally difficult because of the issue of sovereign immunity. And sovereigns enjoy protections from what would be otherwise normal actions in judgment collection that the average judgment debtor doesn't get to enjoy. So it makes it doubly hard for us. I wanted to report to you on a development in the Venezuelan. There's a lot of Venezuelan cases out there, and so I'm going to pick one in particular, the Crystal X case. I do want to say one thing. When people talk about governments, they tend to, especially clients, conflate the government with state-owned enterprises. And you have to have discipline when you're analyzing these claims, because people talk generally about Venezuela or Ecuador or you name it, any other country where there are major judgments against them, Argentina. But you can't do that, because if your judgment or arbitral award flows from an ICSID claim and is against the government improper as opposed to a state-owned enterprise, it's a different kettle of fish than a judgment or arbitral award against one of the state-owned enterprises, which are more like regular businesses and don't enjoy the immunity necessarily that a government enjoys. So it's very important to distinguish between those two species. So I wanted to talk about this development, which is an action brought by Crystal X. Crystal X has an arbitral award, an ICSID award, against the government itself, the government of Venezuela. And so the argument they have made, if you look at this chart, is that they have their judgment, which is an arbitral award converted to judgment, and they have made a claim that PDVSA, which is the state-owned oil company of Venezuela, is the alter ego of Venezuela. And I think anecdotally, conversationally in this room, pretty much everyone who's ever done any study on this probably would agree, just without knowing much more, that it really is an alter ego. And probably most state-owned enterprises don't really operate it truly independently like a regular corporation would operate because they're owned by a sovereign. So there is law that is developed, and I want to go through the specifics of this particular case with regard to how you might attack the assets of a sovereign. In this particular case, if I can draw your eye to the second bullet point, there are two types of sovereign immunity. There's jurisdictional sovereign immunity, and there's sovereign immunity from attachment and execution. Those are two different flavors that you have to take on board, and you cannot conflate those either. Otherwise, you will miss one. So in this particular case, Crystal X seeks a writ of attachment directly against PDVSA's shares in PDVH, which is, as I showed you on the chart, one step down. You see that PDVSA. And they're arguing that as PDVSA is the alter ego of Venezuela, they should have the right to execute on the shares of what it owns. If you look at the bottom row of companies, that's where the billions of dollars in assets exist. They exist down the corporate chart, so there's this layered structure, and the idea is to Pac-Man down through that chart, through that value stream, and this is step one in the process, okay? So what they've done is, the court initially found that by seeking attachment, that Crystal X did not have to prove that there was an independent basis for jurisdiction over PDVSA. So no in personam jurisdiction. We don't care if PDVSA ever comes here or ever goes anywhere. You own shares in a company that is a Delaware company. So they sought to take their arbitral award and convert it to a judgment in Delaware. And that's where this is pending, in Delaware. So number one. So that's a very important development right there. Secondly, you have to overcome sovereign immunity. So putting aside personal jurisdiction, now you've got sovereign immunity. The court said, first, state-owned enterprises are presumptively separate from the sovereign. And the court found that, in fact, PDVSA is presumptively separate from the sovereign, but went on to say, in a very lengthy opinion, which I encourage you all to read, and I can send it to you if you want it, that PDVSA you can get around that independence by virtue of exceptions to immunity. And specifically, the court referred to what is known as the Bosek case. And I'll give you the full name of the case because it's the First National City Bank versus Banco para el Comercio Exterior de Cuba. 462 U.S. 611, 1983, U.S. Supreme Court case. Doesn't get better than that. You've got the Supreme's pronouncement on the issue of when is a state-owned entity separate and apart from the sovereign. And the court went on to the jurisdictional immunity question and looked at what are called the Bosek factors. And the court found, and I'll just go to it. Sorry, let me go up. The court found that, and made factual findings after evidence was taken and discovery was had, that the BROV, or the government of Venezuela, extensively controlled PDVSA's day-to-day operations. That in and of itself is not enough. There has to be more than that. The court found that the government of Venezuela uses PDVSA's property as its own, that it ignored the separate status and corporate formalities, it deprived PDVSA of its independence from political control. It required PDVSA officers to obtain approval for ordinary business transactions. It directed PDVSA to act on behalf of the sovereign state, including paying. One of the most important factors was that PDVSA paid the government of Venezuela's arbitral fees. So the check, the wire transfer to pay for the government of Venezuela's arbitral fees came from PDVSA. That's just moronically stupid. Why they would do that is beyond me. Maybe because they didn't want to expose the Venezuela where the money was hidden, or because Venezuela's broke, which may be the other part of it. But that was really a boneheaded move. Manipulated PDVSA's conversion of U.S. dollars to bolivares to leverage revenues, and found that it used PDVSA to expropriate investments specifically. So the court went on and by virtue of considering those factors, found that, in fact, PDVSA is the alter ego of Venezuela. And that is a huge step. That is a massive step for a court to do that. And this point, Venezuela is a rogue state. It is a failed state. I think there's just no dealing with them on a normal basis, and there's certainly no way you're going to get justice in the courts of Venezuela. That's never going to happen. So the real question is, how do you do it? And this is one of the ways to attack it. This is a massive multi-billion-dollar entity that is existing in part in the United States. And it's really one of the last assets that Venezuela has outside of Venezuela. The second half of the inquiry was on the question of immunity from attachment and execution. The court held that PDVSA's property, meaning first the court collapsed the two into one, so now the Venezuela equals PDVSA, and two, now they're the same. What can we do with that? Well, we'll attach the shares of PDVSA in PDVH, which is a holding company in Venezuela. And the court found that PDVSA's property is not immune from attachment because they were used for commercial activities in the U.S. So the commercial activity exception comes into play, secondly, after you get over the first hurdle. So this is just going back to the chart, you can see now their argument is we control PDVH. That's not the end of the inquiry, unfortunately. I wish it were, but it's not. So the court still has to deal with the realities of what do you do now that you've made this ruling? I mean, how do you deal with this multi-billion-dollar sale of this asset? These shares ultimately lead to the control of billions of dollars in assets. And I believe Crystal X's judgment is $1.2 billion, Christina, $1.2 billion. So there could be surplus. How do you deal with surplus issues? And will there be an insolvency as a result of this? What do you do with regard to lien holders? So it's on appeal right now, and the court refused to grant a stay on the basis that Venezuela did not post a bond, a supersedious bond. Said, well, too bad, so sad. If you want to stop everything, post a bond, and we'll shut all this down, just like anybody else. And of course, they did not do that. So, but that raises the question of what do you do with alleged lien holders that have a lien. So there is a Russian company, a Russian oil company that's come in and said, we have 100% of the shares pledged to us for a loan. Now, whether that's a real loan or not is going to be the subject of a lot of discovery. It's going to be, there may be a sale subject to liens, and that happens quite a bit. Certainly with regard to the liens, if this were in bankruptcy court, there would be an action for equitable subordination, arguably arguing that this lien should be moved down the chain because of improper conduct. So these are all the kinds of things that are still to come. And the court took great pains to say you cannot just, if you're another creditor of Venezuela, you cannot come in and just argue on its face that this is collateral estoppel. Although I see it would be very hard to, another judge may see it differently. She may make a ruling that's completely different than this judge. And so you don't automatically get to own this judgment, this ruling, but it's very helpful to a lot of ground has been plowed for you with regard to going after Venezuelan assets, which are few and far between. So I think this is a clever approach. It was well thought out. It has there have been other settlements recently by the government of Venezuela with other creditors, not creditors of Venezuela, though, creditors of PDVSA. So this one, we'll see very soon what happens. It's on appeal, as I said, in the Third Circuit. If I said Third District, I meant Third Circuit. And we'll see, right? Third or second? Third Circuit. I'm referring to Christina Vicens from my office, who's helping me through this. I'm just repeating what she's taught me. So it is, I think, a very clever use. And if this were to go all the way for sale and ultimately a dismemberment of the company and sale, it would be really interesting to see how that all gets dealt with downstream, because there's going to be other people claiming claims downstream that may be legitimate creditors. Yeah, it's going to be just a huge furball that's going to get unwound at some point. But I know I'm right at 5:28. We're at the end at 5:30. I'll open it up for questions on this and any other topic, and we will take questions, comments. Everyone's thirsty. Everyone wants drinks. Anyone here want to comment or add anything on this? then with that, I would ask you to help me thank the panel for their work. Off to the bar.